Hello, AP Government. I'm so sorry that I can't see you today, but I am super excited that you guys are going to have the opportunity to zoom in and learn more about the judicial branch on today, one of the more historic elections that I and in turn you have lived through. So today we are going to be looking at the judicial branch. Today you should be watching this lecture and taking notes on the video and completing the packet that is attached with this assignment. Both pieces are going to be worth 50% of your grade. So again, 50% of your grade is going to be based on notes from today's lecture, and the other 50% is going to be the completed packet. You should have paper and a writing utensil out, and we will go ahead and get started. So today we are going to be having the lecture on the Supreme Court, known as the Guardian of the Constitution. As we've discussed, we call them the guardian of the Constitution because they determine whether or not laws fall within the purview of the Constitution. So they determine whether or not laws are constitutional. As a reminder, there is a video, so feel free to rewind or in case you need to fill in the notes. So feel free to rewind if I speak too fast, but I will try not to. The most significant aspect of the Supreme Court is this idea of judicial review. Judicial review determines the constitutionality by reviewing issues that violate the rights and liberties protected by the Constitution. This is the third branch's measure of checks and balances called judicial review. So again, judicial review is the Supreme Court's version of checks and balances. In Marbury versus Madison, which we discussed earlier this year, a Supreme Court case, which on February 24th, 1803, declared an act of Congress as unconstitutional, judicial review was established. And the court's opinion, written by Chief Justice John Marshall, is considered to be one of the foundations of U.S. constitutional law. So where does the court's jurisdiction come from? The power for the Supreme Court comes under two different pieces in Article 3. Or it comes from Article 3. Article 3 in the Constitution creates one Supreme Court and under that, inferior courts. So in Article 3, Congress creates the systems underneath the Supreme Court. There are two types of federal courts according to the Constitution at the federal level. We have constitutional courts and special courts. Constitutional courts are often referred to as the regular courts. They include the Supreme Court, the Court of Appeals, district courts, and the U.S. Court of International Trade. Federal courts beneath the Supreme Court, so the courts created by Congress, are known as the inferior courts. Special courts, on the other hand, hear a narrow range of cases related to expressed powers of Congress as referred to Article 1 of the Constitution. So for example, special courts include the Court of Federal Claims, so where the people sue the federal government for damages, military tribunals, courts that govern U.S. territories, the United States Tax Court, the courts of veteran affairs. which all in the courts of veteran affairs hears cases involving matters relating to the veterans of the United States military. One other special court is the Court of the District of Columbia. So because Washington, D.C. is not a state, it needs a special court to perform the functions of that the state court normally would do. There are three major steps in the federal system. There's the district court, which then goes to the Court of Appeals. And finally, this ends at the Supreme Court. In a district court, there are 91 district courts and only one judge. In the Court of Appeals, there are only 12 courts with 3 judges. And finally, we have the Supreme Court, which again is the one Supreme Court, and 9 judges. Looking at federal courts, we're going to look at the principles of the court. So what are the roles of the court? The first is that courts should treat all people the same. And as we know, innocent until proven guilty. However, there are obviously going to be issues within this. So difficulties of justice that we might find in these federal courts are the personal prejudices of that judge, and also the accessibility that some might have for legal fees. So a rich person is going to have a better opportunity to defend themselves properly than somebody of lower socioeconomic status. Now, so this is what courts do. Where do courts exist? So if you sue somebody or you have a court case, where would you go? What is the jurisdiction? There are 4 types of jurisdiction. You have exclusive, which means only the federal court has authority to hear this court case. The state cannot involve itself. You have concurrent jurisdiction, which means either the federal or the state court could hear. You have original jurisdiction, which means the court is the first one to hear the case. And finally, the appellate court or appellate jurisdiction, which means that the court can only hear the case on appeal. Going further into jurisdiction, U.S. district courts have original jurisdiction. And original jurisdiction means that the court has the right to hear the case first. The Court of Appeals has appellate jurisdiction, which means that the court hears an appeal from a court of original jurisdiction. And finally, the Supreme Court has both. The federal district courts serve as both trial courts and appellate courts. And these courts hear appeals from the lower federal courts. And if it gets through all of these different processes, that is what leads it to the Supreme Court. As for Supreme Court justices, let's look at how does one become a Supreme Court justice. The president appoints a Supreme Court justice and the Senate approves. So the president will nominate or appoint a justice, but they have to receive that 2/3 majority from the Senate. There are no official qualifications listed in the Constitution. So as we know, the president must be at least 35 years of age. There isn't anything like that for the Constitution. They must be picked by the current president. So even if President Obama had a good nominee for a judge, he would not be able to do that because he is not the current president. They are appointed for life on good behavior. So long as a Supreme Court justice follows the rules or the guidelines of the Supreme Court, they may stay in that position until they either retire or pass away. And finally, similar to the president, because justices are there for life, one of their checks is that they can be impeached. If you were in a court case and it ends up at the Supreme Court, this is also known as showing up as at the court of last resort. So that means you have gone through potentially state, lower district courts, and you have ended up at the highest court in the land, where they will practice judicial review. So let's look at how a case reaches the Supreme Court. Through a writ of certiorari, sorry, I said that weird, or the rule of 4, which means if 4 Supreme Court justices, so the rule of 4, if 4 of the 9 Supreme Court justices want to hear it, they will listen to that Supreme Court case, or the court will issue a certificate if a lower court says that they do not have to decide on it. So if a lower court appeals to the Supreme Court and says, we do not know what to do, the Supreme Court can then decide that they will listen to that court case. Now, what happens at the Supreme Court is not what you see on a typical show about lawyers. The Supreme Court is much different. So at the Supreme Court, there is no evidence presented and no witnesses are questioned. Instead, an attorney for each side presents his arguments for 30 minutes while being questioned by those justices. After these arguments, the Supreme Court justices will then determine their opinions. So once arguments are over, justices will write opinions, and each justice chooses which opinion to sign. You have the majority opinion, which is called the precedent. You have the dissenting opinion, which is they do not agree with the majority. And you have the concurrent opinion. Now we're going to look at what it means to establish and use a precedent. utilizing the example of Brown versus Board of Education and Plessy versus Ferguson. In common law legal systems, a precedent or authority is a legal case that establishes a principle or rule. This principle or rule is then used by a court or other justice bodies to use when deciding later cases with similar issues or facts. Judges are obliged to make their rulings as consistent as reasonably possible with previous judicial decisions on the same subject. Each case decided by a common law court becomes a precedent or guideline for subsequent decisions involving similar disputes. So, for example, Brown versus Board of Education overturns the decision in Plessy versus Ferguson. And now, whenever a Supreme Court case might visit potential uses of segregation, they will fall back on that decision or precedent made in Brown versus Board to help influence their decision. Now, a stare decisis or decisis is a legal doctrine that obligates courts to follow historical cases when making a ruling on a similar case. Stare decisis ensures that cases with similar scenarios or facts are approached in the same way. So simply put, it binds courts to follow legal precedents set by previous decisions. So again, stare decisis forces judges to use historical rulings to inform their opinions. You don't have to have these people memorized, but it is important to consider where history was made in terms of who are important Supreme Court justices. The first Supreme Court justice ever was John Jay, who was also one of the authors of the Federalist Papers. Thurgood Marshall is the first African-American Supreme Court justice. And Sandra Day O'Connor is the first female Supreme Court justice. This is a photo of our current Supreme Court, except for the exception of Ruth Bader Ginsburg, photographed on the bottom row, second to the right, who passed away on September 18th. The current Chief Justice is John Roberts, who was appointed by George W. Bush, who is in the middle of that front row. Justices Sotomayor and Kagan, the women standing behind Roberts, were appointed by President Obama. And the two men to the right are Justices Gorsuch and Kavanaugh, who were appointed by President Trump. So this is the current court, except for what is currently happening and actually was just confirmed earlier this late last week. After Ruth Bader Ginsburg passed away, there was a large debate over who would replace her. Amy Coney Barrett was nominated by President Trump and has been through the hearings in front of the Senate. She has now been confirmed into the Supreme Court, but this created a large debate amongst Democrats. Because her nomination is so close to the election of 2020, Democrats believe that this is unfair. And one of the concerns they have of this is that it is creating a false majority of political alliances. In a current debate that is currently happening under these issues is whether or not they should expand the number of justices on the court from 9 to 11. That is it for the lecture. Please make sure you can answer both of these questions based off of your notes to make sure you have the key materials. You should now transition to your packet, which is attached to this Google assignment, and submit that. Remember, your notes are 50% of your grade and the packet is the other 50%. I hope you guys have a good and safe day. Please reach out if you have any questions as you see the election unfold. I will be here to support the best that I can. I hope you guys have a great day, and I will see you guys on Wednesday.